Now we got AB 130, which we're going to go over today. And there were four other bills that were enacted last year. We're going to go over SB 410. This has to do with SB 326, the balcony inspection reporting requirements. And then we also have SB 770, which is dealing with electrical vehicle charging station requirements. Specifically, there used to be a requirement of having the making the HOA an additional insured on the homeowner's policy that it got removed. And then we have SB 625. This is disaster reconstruction streamlining. And this bill was aimed specifically to kind of address the problems dealing with the Palisades and the Eden fires in Southern California. And then finally, we have, it seems like we have every single year now, we have an ADU bill, AB 1154. And we're going to go over all of those. But of course, we're going to start with the elephant in the room, AB 130. Now, this is what I call the one big, beautiful bill. It's not just about HOAs. HOAs are a small portion of the whole bill. It's 105 pages, 74 sections, two sections modifying the Davis-Sterling Act, and one other section impacts relating to ADUs. It was a crazy, crazy bill that, quite frankly, pissed off a lot of people, not just people in the HOA, because one of the many things it did supposedly was eliminate requirements for CEQA. So all the environmental people were upset, and then also a lot of people, the builders, were upset because they imposed other requirements on them, even though they were supposed to make this easier for them. So there's a lot of stuff here. But what was the purpose of it? Well, the purpose of this, as you can look at this press release that was issued, the purpose is that it says it's a landmark housing legislation that will speed up construction of new homes and change the course of a housing affordability crisis, passed the California State Assembly today. So what this is basically going to, so eliminating fines or capping the fines is going to result in more affordable housing. So that's where we are, and unfortunately, this is a part of the problem we have to do. And hopefully, we're going to talk to you a little bit about what it did, and hopefully a little bit about how to kind of work around it. So you want to start, Alex, with going over the basic what this is discussing?
Yep. Sounds good. Thanks, Tom. Appreciate the high level overview of everything that's going on tonight. We'll go ahead and get started with AB 130. And what you're looking at on the screen here are four of the key provisions. In truth, as Tom sort of alluded to, there were quite a number of changes that we were fighting against in CLAC that we were hoping that didn't ultimately make it into the final piece of legislation. But at the last moment, we had a number of things that ended up in there. So the biggest one that everybody's probably aware of is the $100 cap on fines per violation. We'll get into it a little bit because I'm sure everybody's wondering, what does per violation mean? We got a slide on that. The other thing is there is an exception to this $100 cap that we will also touch on. But the big broad overview is $100 cap on fines per violation. You'll see also on the slide here, we've got a couple of items about cure. As Tom mentioned, one of the changes that has now been made into law is that owners have been provided with an opportunity not just to cure a violation that has occurred, but also to avoid any discipline or fine being posed on them if they are able to cure that violation by the time the hearing takes place. As I'm sure most of you know, in order to impose disciplinary action via, whether that be a fine or some other sort of action, you have to have a disciplinary hearing. Typically, that's at least 10 days notice. So ultimately, what this law is now allowing for is if you cite somebody for a violation and they cure that violation prior to that hearing taking place, essentially the association is not able to impose discipline on them, even though that violation did occur at some point in time in the past. This other component to curing is dealing with this idea of, well, what happens if an owner can't cure a violation within a particular time frame prior to the hearing? Well, the law has also provided a workaround for that owner in that if that owner can enter into a financial commitment, and we use that term, I'll put air quotes around it because that's the language from the bill. And we're not exactly sure, and I think Craig and Tom will probably touch on this in a little bit as well on their own slides, but there's a lot of uncertainty here with exactly what this language is intending to mean. A financial commitment can mean a bunch of different things. Ultimately, the language of the bill is that if an owner financially commits to a resolution of the violation, then the association cannot impose disciplinary action on them. So overall, you see, Tom pointed out that this bill was designed to create more affordable housing. I think this bill is certainly in favor of owners, generally speaking, but the problem is it's essentially tying an association's hands behind its back with respect to enforceability of its CC&Rs, its operating rules, and any other governing document provisions. Let's go ahead. I'll just touch on that last piece in the bottom right corner of this slide. So one of the components that it didn't change significantly, but it's been made much more explicitly clear is that if an owner and an association disagree on the discipline that or the violation itself and the discipline that's being considered, an IDR must be provided to them after the hearing. That's that internal dispute resolution, sort of the next step in the disciplinary hierarchy, if you will. Let's go ahead and jump into the next slide here, Kristen. So if you recall, I mentioned there is an exception to that $100 fine cap. And what that exception is providing is that if a violation may adversely impact the health or safety of a member's separate interest or the common area, then the association is allowed to impose a greater than $100 fine on that owner. So I'll say it a different way. If there is a particular violation that has a health or safety component to it, let's say, an easy example I like to use is if someone's speeding down the street, any sort of moving violation with a vehicle that can cause health or safety concerns for people, for property, etc. Something like that would still allow the association to impose a greater than $100 fine. There are some caveats to how that process takes place. And you'll see here, it's this determination of that health or safety impact must be made in an open session. Now, again, this is language pretty much coming straight from the bill itself. And we're not exactly sure what that determination is supposed to look like. You see, we're talking about, is this per violation, or can we make a general statement that all violations of a particular nature are health or safety impacts? Are we talking about public shaming? Do we have to identify the exact individual, the exact circumstance, name and shame, such that in order to comply with this legal requirement that we have to make this determination in open meeting? Do we have to have a resolution that's identifying all these different violations in advance? The reality is the law hasn't made it abundantly clear. At my firm at least, what we're doing is we're working with associations to get a sense of their risk tolerance, quite frankly, because some associations are a little more conservative, some are a little more risky, and depending on where you fall on that spectrum, depends on how you would approach an issue like this. But I think the ultimate takeaway is that when we're dealing with fines, if you are concerned about that $100 cap, you can go beyond it, but there need to be some particular steps that are taken ahead of time in order to make sure that your association's on good legal grounds in case that a violation or that member discipline is challenged later. Let's go ahead and jump to the next slide here. So you'll notice on the last page what we talked about, where that determination has to happen in an open meeting. Now, that doesn't mean the disciplinary hearing itself happens in an open meeting. that determination of a health or safety impact is separate from the disciplinary hearing component. Those are two separate things, two separate concepts, although they are ultimately connected and both are needed in order to impose discipline over $100. Disciplinary hearings should still continue to be in executive session. There's really not many times where there's an exception to that rule. In most instances, we're concerned with member privacy and wanting to have a candid conversation with that member about violations. So having it in executive session allows for that to take place. Um, the question does come up about unresolved violations, and I think perhaps Craig can touch a little bit more on that because on the next slide we're going to get to what is an actual violation.
Yes, thank you, Alex and Tom. Yeah, the statute does not define a violation. So really what a court would do is simply look at the plain meaning of a violation, and the court might even look at what the dictionary says. And the dictionary says, not surprisingly, to violate is to break or fail to comply with, right? So that's kind of an obvious definition. So I think it's pretty simple. If there is, you just have to use common sense and a reasonable interpretation as to whether somebody has violated what's in your governing documents, whether that's your operating rules or your CC&Rs. And so once you've made that determination that a violation has taken place, then you can make the determination whether it's an adverse health or safety impact or not. Some things clearly are, some things clearly aren't. And I quote the language of the law, because what the statute actually says is, notwithstanding subdivision C, which is that $100 cap, the board may impose a penalty stated in the schedule that is greater than $100 if the violation may result in an adverse health or safety impact on the common area or another association member. So apparently, if this health or safety impact only applies to the violator's property, I don't know that you can fine more than $100. That's just bad wording. So the next question in this slide, can each day be a separate violation? I mean, if you find it, the best you can do, in my opinion, and perhaps Tom and Alex can chip in, is define a violation as per day. Is a court going to buy it? Maybe, maybe not. I mean, the court could say, look, the statute says $100 per violation. That's it. You paint your house pink one day, that's one violation, and it can be pink for a year, and that's only one violation, and it's not an adverse health or safety impact. So really, one thing I want to emphasize about this law is in my 15 years or so being involved in CLAC, never has any law that I can recall, Tom has a longer memory than me, but never have I seen a law which is subject to so much or different interpretations of among experienced lawyers. I mean, this could mean anything to three different very experienced community association lawyers. So that's why there's that extra emphasis to talk with your own HOA's counsel, right? Okay, so what is can each day be a separate violation? You can try. You can define closely as you can in your operating rules, but whether that's going to be upheld is anyone's guess. Next slide, please. Oh, yes, this one I love. No disciplinary action can be taken if the violation is cured by the time of the hearing. So, if you have a parking violator, always parking in the guest spots, and he does it every day, but, he leaves for work in the morning and comes back, parks in the guest spot, and then you call him into a hearing and say, hey, we're going to impose a $100 fine against you. He says, well, I moved my car. What are you going to do? He's cured. So again, I think the best approach, and Alex and Tom will have their opinions as well, and so will your attorney, is that you just have to define it. A violation is an occurrence whereby there is a car parked in the guest spot, and that's one violation. do your best to define that in your operating rules, to avoid this sort of rinse and repeat behavior where you can never, because that's truly not what they intended, right? Is for people to be able to just park wherever they want with no consequence. But that's kind of what's happening. So does the owner get to cure? Disciplinary action can be taken if the violation cannot be cured by the time of the hearing, but the owner has entered into a financial commitment violation. I mean, this is just ridiculous. I'm sorry. I agree with what Alex says. That terminology has never entered into the lexicon of fines and violations in the Common Interest Development Act ever. So what does that mean? To cure the violation, say you parked your RV out front and it's been there for a month now, and is that how many violations is that? And what is your commitment to a financial violation that you're going to put a down payment somewhere on an RV parking lot somewhere off site? What does it mean? Or you're gonna put a down payment on a house painter to come and repaint your house from pink to gray or whatever it's supposed to be? It's just really up to a lot of interpretation, and frankly, I don't know what it means, and that's sad to say. But you can have your own counsel advise you on what that should mean for you and your governing documents. That's that. I'm sorry, that's the best I can offer you on that one. Uh, and also, I just want to say, just jumping back, because Tom had said he accidentally said it was January that they put the language in. Just to be clear, they put this language in June 25th, and then it was signed into law on June 30th, and it became the law July 1. So 5 days, okay, that this was put into the law and became effective. So I'm just really upset about that. So I want to make sure that point got across. Okay, next slide, please. Okay, if they haven't cured by the time of the hearing, yes, you can find them. You can find them there $100, or if it's an adverse health or safety impact, you can find them a greater amount. But you have to make those findings in open session. Okay, now the second one is if they cure by the time of the hearing, but then do it again, have they really cured? No, and in my opinion, no, but it's again really going to come down to crafting your operating rules in a way that you can catch them and identify each act as a violation. The classic example being parking in the guest permit or guest parking. Um, sure, they moved their car before the hearing, but the damage has been done, in my opinion. The community's been deprived of that visitor parking space for X amount of time, and that's a violation. And I think that is, persuasive enough where you would have a court's ear on that. But again, you'll have to work with your counsel and violation in a way that's enforceable. Hope it helps. Next slide.
So,
Yeah, go ahead.
yeah, I'll jump back in on this. So, yeah, I think to Craig's point, a lot of what we found with AB 130 is that your documents, your governing documents, specifically your enforcement policies, schedule of fines, whatever that document about enforcement is called for your association, it needs to be updated. It needs to be reworked, and we need to incorporate some particular definitions in there that will help you as an association continue to enforce your documents. The good thing is, as far as reimbursement assessments are concerned, those have not been impacted. AB 130 was specifically designed for violations and the monetary penalties that are associated with those violations. It did not impact anything to do with reimbursement assessments. And these typically come up when an owner has failed to do something. They've typically breached their CC&Rs or rules because they have either, let's say, they failed to keep up with their landscaping, or they've made a particular architectural change in violation of their governing documents. And the association sent out a notice. They've sent out two notices. They've called them to a hearing, and eventually in most cases, your governing documents will allow you to, upon proper notice, go ahead and perform that work and then bill the owner back for that work via a reimbursement assessment. And the good news is the AB 130 has not impacted that ability. I would still recommend that your documents be reviewed just to make sure that there's nothing funky going on, but ultimately, you're still in a good place when it comes to reimbursement assessments. And you'll see there's a couple of points that are made towards the bottom of the slide. The costs of enforcement. I get a lot of boards that ask me, well, they have to come to council or they have to come to have extra time with their manager to work through a particular enforcement issue. And there is the ability in some instances to include those costs in your reimbursement assessment. So it does depend on whether your documents allow it. I think the more clear your CC&Rs are with respect to that issue, the better your position. So it is a little bit of a case-by-case situation, but if your documents have that language, it would be helpful for you to be able to rely on it. All right, let's jump to the next slide, please. Simple question here. Can the association levy a reimbursement assessment to recover the cost of addressing a violation? Yeah, I mean, this is exactly the sort of issue that we were talking about. Let's say, landscaping or architectural approval. This example scenario is a perfect one where if there's trash cans or trash generally that the owner has failed to clean up or otherwise comply with the CC&Rs, this is a situation where the association can, in most instances, go in, perform the work, and then bill the owner by a reimbursement assessment after the fact. There's always some notice requirements that go in that go along with it. You want to play these things as conservatively as possible, typically, because if they get challenged, you want to have the paper trail there to protect you. But for the most part, reimbursement assessments are still good to go. All right, let's jump to the next one.
Okay, this is ADU fees. Now, this is part of that what I was mentioning before, this huge bill. The ADU changes aren't specifically in the Davis-Sterling Act, but as part of the 105 pages buried in there is some what arguably minor tweaks to the ADU laws that were both in the government code and in the civil code. And one of the changes they made was to the civil code is that you can no longer charge a fee or deposit, arguably for the approval of an ADU. And so that would arguably prohibit the homeowners association from charging for an architectural application for the ADU. Because it's not in the Davis-Sterling Act specifically, there's some ambiguity to that. I think if the ADU is part of a bigger application project, like a big renovation and the ADU is there, probably you're fine. But nonetheless, it doesn't really specify that. And so this again is one of those little things. It got thrown in right at the end. Somebody thought this was important for regular ADUs. Nobody got to talk about the ambiguity that it creates as a result of throwing it in without specifying how it reconciles with the association's deed restrictions. But it does specifically state in the civil code section that got amended that it applies to deed restrictions. So theoretically, that applies to homeowners associations as well, even though it doesn't specifically show up in the Davis-Sterling Act. So let's go to the next slide, Kristen. Now, obviously, Alex and Craig and I've all talked about these big changes about AB 130. And I don't think it's just the changes, as both Alex and Craig mentioned, it's the uncertainty that comes from the changes. Because what is the violation? I do agree with Alex and Craig. You should be defining that in your rules about changing it. So, if you want to basically potentially have to fine for each day, week, month, or whatever it is appropriate to try to compel compliance, you're gonna have to define that in your documents itself to make sure it's clear that you're talking about that. And I agree, cure is so crazy that I said there was a question in the Q&As asking, well, what about short-term rentals? because somebody's short-term rental rented out for 5 days, then of course it's done by the time you got to the hearing. Have they cured it? I think you'd have to define whether or not that type of cure means anything. That no, argue that's the fact that it's not occurring at the time of the hearing by itself doesn't mean it has been cured. There's got to be some type of resolution of that dispute. But in the meantime, we have all this dispute and we have the potential for litigation. And I would say just generally to all of you that in addition to doing general counsel, I've been a litigator for 30 years, and the thing I know about fines is courts don't like them. They don't like fines. So you still, even if you can find a work around these fines, you got to make sure you're using them judiciously, because the key is to compel compliance. And so if your fines are being levied, and they're large, they could even be large. For example, you could be in a big gated community with celebrities that are renting their house out for party houses. Okay, well, you're not going to compel a celebrity for levying $100 fine, and if you had something more significant there, and to compel the compliance, I think courts are more receptive to that than not. But of course, if there are trash cans out there every day for 5 days, so I fine them $500. I don't think court's going to like that. So just be judicious about that. That's one thing I would emphasize. And in the meantime, I'm a little like a kind of foreshadowing of where we're going to go here. We're going to have to talk a little bit about what's coming down the pipe this year. And one of the things that is coming down the pipe is there is one of the legislators is proposing a bill to kind of limit the impact of AB 130. It's not going to be to repeal it, but she's going to try to limit or specify more precisely additional exceptions that aren't necessarily health and safety exceptions to this $100 rule, and hopefully try to deal with the cure issues that we've kind of talked about. But this is something that is kind of interesting about the legislative process is she's introduced it as a spot bill. So right now there is no language. She's trying to generate language. And so you can help with this, because if your homeowners associations are having problems specifically, then use this QR code here and send us examples of the problems this has caused for you. And hopefully we can use that to help her draft exceptions to the AB 130 that, hopefully will at least clarify and mitigate the chaos that has been created by AB 130. So, Craig, I think we're going to talk about a different bill now, SB 410.
A different bill. Just one last thing on AB 130. All I want to say is that it was brought in the name of affordable housing. It's having the opposite effect, because it's forcing HOAs to accelerate their dispute resolution process, get attorneys involved in earlier, go to court earlier, because $100 fines don't matter that much. Okay, something else maybe you could tell your legislator. Okay, thank you. Well, let's move on from AB 130. Jeez, that just drives us crazy. Okay, this one was SB 410, having to do with those infamous exterior elevated elements we've come to know and love. And I don't have too much problems with this bill. It first of all, it added some additional information that the reports need to include. Your expert should know about these, but it has to include now the date of the inspection, total numbers of condominium units in the project, total number of condominium units with EEEs. Should we just call them EEEs? The total number of exterior elements inspected, and as of the date of the inspection, the number that of those exterior elevated elements, say that 10 times real fast, which pose an immediate threat to the safety of the occupants. And finally, a certification that the inspector has conducted a visual inspection of a statistically significant sample. And so those are the new things that have to be in that report. Now, another thing, which also, whether you like having to share the report or not, now that report must be shared to prospective purchasers, and it's also one of the defined association records, which at least because I know managers and attorneys were like, well, does this record? But now at least we have that answered, for better or for worse. Because a lot of times those reports aren't very good, and you're maybe not so proud of them, but at least they're out there in the public now. Okay, and so it also clarifies that it only applies to buildings containing 3 or more attached family dwelling units. So, I think reasonable bill, more reasonable
You
than
know,
AB 130. Yeah.
Craig, there was one thing I was going to mention. I spoke with a person that does these sorts of repairs, and he showed me one of the reports that he had. And I think perhaps you've had a different experience. He did an inspection report for 15 units, and I think it was over 500 pages in the report. So something that came to my attention was that for those managers, for those board members that review these reports, or get requests for these reports, you may want to consider some form of redaction depending on what information is contained. In at least the example report I saw, which again was over 500 pages, and perhaps that's not the norm, there were a number of pictures that would show the inside of particular units. Even though they were capturing the balcony or the deck from the outside, they would be viewing inside, things of that nature. So boards would just want to be careful about some of these reports can be extremely lengthy depending on which company you're working with. So you could have that issue, or you could have the issue that Craig's describing, which is that they're not great and they don't have a ton of information in them.
Or the information they have is really bad for the community in terms of the dire need of repairs, which I've seen all too often. But that's a good point. Maybe one of the things, the notices that should go out is uh, residents, please remember to close your blinds before they do the inspection. You know, I never thought about that. Good point. Again, this next slide just goes to the point that now these reports are required to be disclosed to prospective purchasers and to anyone that asks for them as part of an association records request. And next slide. Okay, that's the stuff I was talking about earlier. These are the additional things that need to be included in the report. And rather than me just rattle them off, you can just take a moment and read them for yourselves. Again, your expert will include this. It's not like you have to memorize them. But you should know, like maybe the expert you've hired doesn't know about the new law, and you'll know as the manager or the owner that this should have been included in the report.
Okay. Electrical vehicle charging stations. What I said in the intro is that for years he had like a bunch of conditions that supposedly were going to insulate the association from permitting the homeowners from installing their own charging stations, and one of them had to do with adding the association as an additional insured. And unfortunately, we as CLAP, we introduced a lot of testimony and suggestion that it really the cost to the homeowner to add as an additional insured is a lot less than the potential insurance impact on the homeowners association if they're in essence the master is going to cover these type of anything that arises out of this. But unfortunately, that fell in deaf ears, and so it was left in there. So now it's pulled that requirement out. But Senator Allen, who was the one that's carried this bill, he did recognize that there's a potential burden that he was putting on the homeowners association. And so again, he's got a spot bill this year that is supposedly going to mitigate that risk to homeowners associations by at least clarifying that the homeowner, if they don't get the insurance or add them as additional insured, might have some type of obligation to indemnify the homeowner association. So that's one thing that's out there potentially, but again, the language is not in print yet, so we don't know for certain how it's going to look. So, but anyway, that's on the way.
Yep. Alrighty, so here we're going to talk about SB 625, which, as Tom mentioned earlier, was a response to the wildfires down in Southern California. And this, in my opinion, is an example of a bill that did a good job in keeping things a little more clear. The overall takeaway is that for an association that has received an application to rebuild something, to rebuild a property in the community, if it's damage due to a disaster, and disaster is declared by federal government, by the governor, or a local governing body. So we've got a lot of different options on how that disaster can be called out. If the application is for a property that is substantially similar, then there is a streamlined process for approval. Now, unlike AB 130, here in SB 625, that term substantially similar has been provided with a little more clarity, and we have a good definition of it. So let's jump to the next page and we can get started in that. So this is the overall idea, is that a substantially similar reconstruction is a building that does all of the following. So let's jump over to the next page, please. The interior livable square footage is not more than 110% of the destroyed structure. You'll see that 110% used as a sort of a baseline throughout the language here. Exterior footprint has to be essentially the same. Setbacks have to remain at least 4 feet from the side and from the rear. And then on the next page, you'll see height can't be more than 110% of the pre-existing height, or 100% of what the governing documents allow. Additionally, this doesn't preclude an association from imposing some of its own design standards if they have properly adopted architectural rules or design standards, as long as it doesn't unreasonably increase the cost or ultimately, effectively prohibit the construction. So here, like I said, it's an example of a bill where they said something has to be substantially similar, and they've given us rather clear boundaries and definitions of how an owner can meet that and what an association has to do if they're provided with something to that meets this criteria. It's pretty objective criteria, all things considered. All right. Jumping over to you, Craig.
Sorry, unmuting myself here. Okay, and I agree with Alex that they did a much better job than they have in other areas of giving us some clear language to go by. And one of them is the objective design standard, means a standard that involves no personal or subjective judgment and is uniformly verifiable by reference to an external or uniform benchmark, knowable by both the applicant and the association before submittal. I mean, that sounds great, and it's pretty clear how that's going to work when the rubber hits the road, and someone's rebuilding and there are plans. I think you're just going to have to use your reasonable judgment. And if there is a dispute, consult with an expert, an architect or a design professional, to help guide you as to whether it meets this objective design standard. And so hopefully that will guide you through a process. Hopefully you don't go through a major disaster, but we've seen that happens. And the other thing to be cognizant of is there is a 30-day to uh, to determine whether the application is complete. Doesn't necessarily mean there is automatic approval if you don't meet that deadline, but it just starts to give the other side leverage in what if there's any dispute that arises. So be conscious of that 30-day deadline. And here's the reason, is because a court shall award attorney's fees to the owner of a separate interest in action to enforce section. Now, this seems to be one-way attorney's fees clause, because it doesn't just say the prevailing party, it says an owner shall prevail. So, if the owner doesn't win, then it doesn't seem like the association gets its attorney's fees, which has been kind of a common theme in recent legislation they've enacted, where they're carving out that general rule, whether the prevailing party, HOA or association or owner, gets their attorney's fees if they win. Here, the owner gets their attorney's fees.
Alrighty. So we're jumping over to AB 1154. This is dealing with accessory dwelling units. Specifically, it's actually dealing with junior accessory dwelling units. So those are these structures that are capped at 500 square feet. So they're typically smaller. A lot of people think of them like a garage conversion. That's a pretty standard sort of JADU that I've seen with associations. There wasn't a ton to this bill. As you can see, it's not a direct impact on homeowners associations. There was an amendment made to the government code, which is where a lot of the ADU and JADU language actually comes from. And ultimately, what it has done is it's removed the requirement that an owner occupy the primary unit as long as the JADU has its own restroom sanitation facilities. So previously, if it did not have, if that JADU did not have its own sanitation facilities, then an owner was required to live on site in that primary portion of the property. But the JADU bill 1154 has removed that requirement. So now the owner does not have to remain on site. It's a pretty short bill. There wasn't a ton to it. There was a specific goal that they had with this one, and they seem to have accomplished it. Not too bad. All right.
Okay, now we're talking about what's coming down the pipe. I've already alluded to two issues that are coming down the pipe, but there's some other, and by the way, I got a list this morning of all the bills that we think are impacting HOAs, and it's not going to be complete because just as I mentioned, I'm aware of two spot bills that are going to be gutted and amended to deal with HOAs. There's probably other stuff that we don't know about yet. But of the stuff that we do, there's a few things that I think are pertinent to talk about. One of which is a CLAC sponsored bill, and that's AB 2050, and it deals with it deals with reserves specifically, but it's designed to deal with some of the older condominium projects that are having trouble with, funding the infrastructure repairs because they haven't, adequately contributed to the reserves over many years. So what bill is looking at doing is to have the reserve setting like a mandatory funding level minimum. It's not like a high thing on it, but it set a mandatory funding for meeting a certain percentage as recommended by the reserve study professionals. And it's not going to be like you have to comply with this tomorrow. It's got to ramp up. You have to get till 2032 before you actually have to be in compliance with it. So people will have time to kind of learn how to deal with it. And the other thing that I think is interesting and helpful for, I think, managers and boards is that it will have a right to levy, if it's adopted in this form, a right to levy a reserve assessment to kind of bring the reserves into compliance with the study without having to go through the membership vote process. So that's like an actually very significant bill that we're going to deal with, and I'm sure you'll hear more about it. On the opposite side of that, something I think is like the antithesis of the reserve bill is this SB 1007. It deals with assessments and discipline. And in this case, again, in the name of affordable housing, the senator wants to cap or prevent boards from raising their regular assessments on the annual basis. Right now, you can raise it 20% without a vote of the members, and this senator is trying to limit the ability to do so. You want to limit the ability to raise it to the rate of inflation, and it's a little bit ambiguous how we're going to measure that, but rate of inflation, which is going to be significantly less than 20%, and then you'd have to go out for 20%, which, quite frankly, that type of limit on boards in this age when we have this deteriorating infrastructure. And then you mentioned SB 326. There's a lot of associations out there that are struggling with how to fund SB 326 repairs. And if you can't basically raise your assessments 20%, it's going to create a little bit of a loggerhead, and there's not going to be ability to comply with some of these requirements that have been foisted upon the homeowners association. And then there's another aspect of this, which is part of the budget process. They want to make sure that all the annual budget reports have some kind of visual aid. I don't know, like maybe a pie graph or something, because apparently the people can't, they're not having trouble understanding them. So they're going to put that in there. And then finally, there's going to be, this one is less of a concern to me, but it is a significant change to the disciplinary process in that it would require a homeowners association, if they have any evidence of what they're going to levy the fine based on, to provide that evidence to the homeowner in advance of the hearings. I mean, some associations kind of effectively do this in any event, but right now it's not legally required. And so that's what would be required as part of that. And then also we have AB 1892, which is it's actually a helpful one. This is like an election cleanup bill that CLAC supports. The bill is going to clarify that an HOA is it's two things. One, a couple of years ago, there was that bill that required the HOA to make repairs to certain interruption of gas, heat, or water. And there's some ambiguity whether or not the HOA had to fix that if the interruption to these gas lines or water lines occurred inside the unit. And this is clarifying that the HOA only would have to do that if it emanates from a common area connection. And the other part of it is, and I think a lot of people will be happy about this, it's going to it proposes to shorten the initial period for elections for acclamation. So right now it's kind of the acclamation process is almost useless because you have to have like a 90 days, before the ballots go out, or before the nominations are completed for the director. You have to disclose that there's this possibility that the directors can be elected by acclamation if not enough people run for the board to meet the number of seats that are open. And the silly part about that is you had to start the 60 days, then you would have to start before the actual election on the regular directors. And sometimes associations don't know if this is going to be a problem until after they have completed the nomination standpoint. So it's going to rectify that, which I think would be a good thing. And then finally, the ones I'm going to talk about is SB 1238. This again, Senator Wahab, who adopted AB 130, and she's got another killer bill which has about 20 things in there that I could talk about that are bad, but among them is that she is going to require that actually this goes back to SB 410. One of the things that we stopped from going into SB 410 was the requirement that the inspectors had to put in the total number of elevated units, but they also had to put in specifically how many have to be fixed within the first year, how many have to be fixed within 3 years, how many have had to fix within I forget, was it 6 or 7 years. And the problem was the engineering lobby said, we won't do that. If you basically make that a requirement, we're not going to issue these reports. So it got taken out. So she's put that back in here on this. And she also has a lot of other issues too, dealing with disclosures of this. She creates more disclosures. Right now, technically, a homeowners association doesn't have a duty to make disclosures to buyers. And this bill would require them to make a lot of disclosures to the buyer, which would, quite frankly, open up liability to them. And then the other thing it proposes to do is to tie in a better way the reserve study to the SB 326 reports. So this part is kind of consistent with what the clock bill is trying to put them so that the reserve study is accommodating or coming up with a funding plan for the SB 326 repair. So that's what's in that bill. And there's also other bills dealing with like requiring HOAs to permit cooling systems, regardless of whether or not they have or HVAC systems, regardless of whether or not there's any infrastructure to support it. There's another one on heat pumps, and again, similar. There's no recognition about whether or not the HOA can facilitate the infrastructure on it, or even considering the potential impacts on that. So those are bills that we're all going to be watching, and I'm sure as we go along, there's going to be more added to that. So,
Yep.
Alex, you want to talk briefly about these?
Let's do it.
Case law.
Sounds good. Yep, we'll start with a good one here for homeowners associations. Eng versus Opperman. I'll keep it very brief on the facts. Essentially, owners wanted to convert their garage into an ADU, and the association denied it on grounds after consulting with their architect, who reviewed the application. They denied it on particular grounds related to traffic safety. They had these owners where this house was located had shared driveways with other owners, and because of the way everything was laid out, the association felt that the garage conversion would impact the traffic safety. Long story short is that the court agreed with the board and ultimately found that the board of directors fulfilled the business judgment rule and were provided with deference under the judicial deference. We refer to it as the Lambden deference due to a very famous court case that homeowners association attorneys are frequently referring to. So this was the first court to apply that Lambden deference to the review of an architectural application. So it's nice from our perspective to see something that's quite secure from board perspective expanded into other areas. And really the big takeaway is you have to conduct a reasonable investigation. You need to work with your experts, but assuming that you are doing your due diligence into why an application should not be approved, courts will likely rule in your favor and give you that deference as long as those steps are all taken. So keep working with your experts and make sure you've got objective architectural standards in place, and that will help you in case this ever comes your way.
Okay, this is like one of the craziest cases that I've seen, and my good buddy here, David Graff, I'd like to see him come up with a limerick for a case law, because this one is like crazy. $1.8 million in HOA was held liable, but not just the HOA, but the board president. And talking as somebody who's spent a lot of time, defending D&O claims, I could tell you that is really hard to do. But in this case, Mr. Moritz actually found a way to do it. So if you go to the next slide here, this is really what I call bad facts make bad law. HOA here, in this case, there was like an underground well. Then below a unit, the homeowner basically was claiming a mold in their unit or water intrusion. And the HOA actually at some point in time got an opinion from their legal counsel that kind of told them, hey, guess what? I think there's an underground well there, and you as an HOA have a duty to fix it. And then for some reason they tender to the carrier. Well, that part's not for some reason. They tender to the carrier comes in, and the carrier basically figures out appoints defense counsel, and defense counsel decides, oh yeah, we'll get some experts. We don't have to do that. They never disclosed any of their experts that they knew that this well was a big source of the water intrusion, because they were thinking, well, maybe it should be if anybody has to fix the well, it should be the city, as opposed to basically ignoring the opinion that they had received from legal counsel, say that you still have an obligation. This is common error. You got to have the obligation to investigate, and then if necessary, cap it. And then, of course, if you want to go sue the city, go sue the city. But they didn't do that, and they ignored stuff. They covered up reports. And ironically, the attorney somehow disclosed this legal opinion in discovery, didn't seek to claw it back. And at trial, he became a witness in the case. And had when the court basically examining him, and the court in essence made findings that the association and the presidents had basically acted at the very least with gross negligence, but arguably bordering on fraud. So they end up whacking with this and a lot of this and said, hey, they tried to defend this based on the business judgment rule, but one of the key parts of the business judgment rule is good faith. And they said, hey, you're nowhere near good faith on this one. So it's the key there, act in good faith, don't try to cover up things. Don't try to, avoid having to make a repair simply because you think it might be too costly.
Thanks, Tom. Yeah, and we have another case. It came in at the end of 2024, but close enough to 2025 that we included it because it was a good case, kind of on the opposite side of having to do something. This case was Woolard v. Regent Real Estate Services Inc. And so many of us have been in the position where owner A is like, owner B is harassing me. They please take up your time, board, take up your time and attorney expense and go after owner B. And then owner B says, I'm not doing anything. It's owner A that's harassing me. And what is the board supposed to do? Well, fortunately, in Woolard, which is a case that I think a lot of us were waiting to come down, the court said, look, HOAs don't have police powers. HOAs don't have subpoena powers. They cannot compel owners to sit down and work out their differences. They cannot adjudicate differences except in very limited circumstances, in the context of violating the association's governing documents. And the court declined to recognize a duty of care, a new duty of care, requiring an HOA or its management company to involve itself in disputes between homeowners outside the confines of the governing documents. Now that's a little bit vague, but we'll take it as a win. There is some question about the applicability of this case because this case did involve tenants, but I think it's still a good guiding principle for, HOAs do not have to get involved in owner-to-owner disputes, and it's something we've hoped for a long time. Next slide. Okay, for the collections nerds out there, such as myself, a couple years ago there was a new law again in the name of housing affordability, where when a bank forecloses, then somebody else at the foreclosure sale, a third party who they provide housing for low-income people, or they're the former tenant or former, the former tenant can also put in these post-sale bids, is what we'll call. And now these companies that come in and say that they're doing it for low housing income people, they're every case I've seen are just complete fraud. So, take it as what it is. This case said that the post-sale bid procedures also apply to HOA foreclosures because the law said only mortgages or deeds of trust. And I said, no, an HOA lien is not a mortgage or deed of trust, but and according to the Court of Appeal, and that means I was wrong. And yes, these post-sale bids do apply to HOA foreclosures. So it just injects some more uncertainty in the non-judicial foreclosure context. So about that.
Okay, so I guess now it's David's turn to talk about Colorado law.
Hey everybody, David Graff from Olegraph here in Colorado. Don't have a heck of a lot going on in 2025. Just so I'm clear, we're done in the next 20 minutes. We're going to take some questions or no? What time
you have 30 minutes and then we'll leave time for questions.
Oh, okay, so I may need to reach back in time to talk about what's gone on in the last several years. In Colorado, we had a high water mark in 2005 and then again in 2022 in terms of HOA specific legislation. And 2025 was relatively light. Do you mind advancing the slide? Or can I do it? I don't think I can. So we had a bill similar to the bill in 2005, which was the Homeowner Protection Act of 2006, another bill concerning the protection of owners, which is a little scary thing because Colorado is a Uniform Act state based on the Uniform Common Interest Ownership Act. And the preamble to our bill, our common interest community statutes, say that associations that are well-funded and running properly help homeowners. And in the last 20 years, we've had one bill after another protecting owners from their homeowners associations. 1043 from 2025 was no exception. Relatively minor compared to the reeling that we've taken over the last several years, but we do have an obligation to affirmatively request owner telephone numbers and email addresses. Not a huge issue, and it's not defined as what periodically means. But the reason we have to do that is that we have to give notices of delinquencies by several of these methods. And if we can't do that, then we got a problem. Now, interestingly enough, once we have these email and addresses and phone numbers of the homeowners, we can't give them out. There's a state statute, Kiowas 317, that does not allow us to give out email addresses and phone numbers of homeowners unless the association is publishing a directory and every owner has consented to their data being included in that. Next slide, please. Thank you. So still, the main bill from 2025 was 1043. Again, I'll talk a little bit about the history that led us to this with time permitting, but we now have to provide a ledger within 7 days of the owner's request, and we have to provide advisements to the homeowners in our collection letters, particularly about how to access consumer credit counseling and the state HOA information office. And that's new. We haven't had to provide those advisements in the past. They're relatively benign, I think. It just loads up the letters that we send to the homeowners, dilutes the message perhaps in long or lengthy, scary advisories. Next slide, please. Now, pre-foreclosure. So Colorado, and now I'm going to start going back a little bit in time just to give you more of the picture since I have 30 minutes, which I don't have to use, and I can be voted off the stage here at any moment by you. But in 2022 is a significant consumer protection bill, both on the collection side and the covenant enforcement side. And it was that they restricted the association's ability to foreclose. And so when I talk about pre-foreclosure, or meaning before an association does a foreclosure, there are additional things that we as an association have to do before we can bring forth a foreclosure. And the minimum balance of assessments due has to reach a certain amount before we can foreclose. If we don't have an underlying judgment for the debt, then we have to either get one, or sometimes we foreclose because we can't serve the owner or because they've moved out. And we have to try in good faith for 6 months and be unable to pursue that judgment in a different court, usually, before we can apply to the district court, a higher level court, for a foreclosure. So there's a whole bunch of, pump the brakes statutory mechanisms on preventing associations from foreclosing. The obvious ones, the management company people and the lawyers can't bid on the foreclosure sales, which, believe it or not, has happened in the past. It can't happen anymore. But the foreclosures are very, very difficult to prosecute. And under Colorado law, any owner has the ability to pay an unpaid, a past due assessment over 18 months. And this is from 2022 as well. And there's some language in the statute as it applies to pre-foreclosure. It's not quite clear if it's limited to pre-foreclosure cases, where the homeowner gets to pay over 18 months, and they get to choose the amount of the payment as long as it's more than $25 per month for 18 months. And so arguably, if you're going to foreclose on someone and they want to pay $25 a month for 18 months and have a balloon in the 19th month, they can do that. So that's where we are. In 2025, they updated the additional requirements that we have to provide from credit counseling. And again, we have to request the telephone number and an email address from the owner before we send some of these notices. So we have to try to get additional methods of contacting the owner before we then send the letter to contact the owner about what's going on. Next slide, please. Thank you. And one of the things that we've argued with, and the statutes have changed over the last couple of years, is how do we get notices to the owners? How do we do this? In 2022, we had to post the notice of delinquency on people's units, and that's what it said, on their units. Raw ground, you'd probably put it on a sign and pound a stake into the ground. But that was originally compromised because the statute said that unless you could place the proposed bill, I should say, unless you can place the notice of delinquency in the owner's hands, the collection cannot proceed. And a compromise was to post the notice on the door. That was taken out in 2023. And ironically, I think it was one of the few things that was working really well was posting notices on people's doors. Now, that most people are not used to having legal notices, delinquent notices posted on their door. But from my personal perspective, it was getting people's attention. And when we get people's attention, we can have a conversation, and then we can start to talk about how we can resolve that outstanding balance. So they took out the posting in 2023. In 2024, they said you got to send notice either by text, email, or voicemail. And it wasn't clear if you gave a voicemail to a homeowner, left a voicemail, I was going to say on their answering machine, which shows how old I am, whether you have to read a 2-page delinquency notice as part of the message, or can you just get their attention? But anyway, 2022, 23, and 24, management companies in Colorado have been scrambling to adjust their practices and their forms and their notices to comply with the continually changing statutes. And so for 2025, we have to send notice via certified mail, which usually proves that the homeowner didn't get the letter because they don't claim it often. And we have to do at least 2 of the following: a phone call, a text message, an email, or by regular mail. And the preference is for text and emails because that's how many people communicate these days. But again, in the context of having to request that information and specifically having to write the letter to the owner requesting that before you do a foreclosure, we want to be scrupulously careful on phone calls, text messages, and emails, because that's what statutory preference is. And it's, and maybe I'm just old. I haven't really loved the idea of texting people institutionally. I'm collecting those texts and keeping those texts and dealing with bounce backs and all that, but statute is what it is. Next slide, please. So the other thing is the homeowner has the right to mediate, and this was new in 2025, and we have to give them, options on mediation in terms of telling them that's a thing that they can avail themselves of. I think mediation is a great thing. I would try to mediate all of my cases. Now, in Colorado, when we sue someone in almost any court at any level except small claims, even in small claims, you have to mediate. You have to mediate before the court will give you a trial date. So we already have to mediate pre-lawsuit. I don't have a problem personally with mediating pre-filing of the lawsuit, but it leaves kind of an open question as to who bears the cost. And the reason I say that is because in 2024, Colorado legislature said to the associations, you can collect up to 50% of your legal fees for covenant or collections. And if you go to court and ask the judge can find that the person was, and I can't remember the litany, but practically, physically, perhaps not emotionally, but able to pay and chose not to, then the court may allow you to go above the cap, and there's a statutory cap of $5,000. So we're subsidizing, the association is absorbing a subsidy of 50% of the association's legal fees for collections and covenants. And when we add on the right to mediate, the question, well, who bears the cost of that? Well, the association, best case scenario, bears at least the 50% of the legal fees and potentially more. So a little bit sensitive issue here. I don't know if California yet has limited the amount of legal fees to a blanket subsidy of the maximum that an association can recover, even if it prevails. But that's where we are right now. Next slide, please. I think we're almost done here. Okay. Another thing that I think is helpful from 2025's 1043 is we have to send out written and email notice, if we have the ability to, of a foreclosure that the association would bring to all lien holders, people who have a recorded interest in the property. A little bit more administrative work to do. Often, not often, every once in a while, we get a lien holder that will pay. They will pay the debt, and they will absorb that roll it into the balance that the owner owes, because they've retained the right to do that when you borrow the money as a borrower. Sometimes that's a really great solution, elegant solution to an association collection issue when the bank pays. And so I hold out hope that this will not only prevent people saying that we provided an unauthorized FDCPA or Fair Debt Collection Practices Act disclosure to a third party, the bank, but I think it also, holds out the possibility that the association gets paid by the lender and the homeowner gets to amortize that debt over perhaps many months or years. So I think that's probably a good thing, but it does create a little bit more administrative burden and resulting cost. Next slide, please. Okay, so we have an HOA information office, if no one knew that, here in Colorado. And that was created about 2013. In 2015, Colorado had a manager licensing law pass that took effect in 2017. And then when the bill was proposed, it was automatically set to sunset or expire, which I think is a good thing. We don't keep building up this huge body of laws that don't automatically expire. And in 2020, I believe it was, when the bill was set to expire, industry pushed the sunset extension, meaning it would continue on, passed through the legislature, and the governor vetoed it. So we don't have manager licensing. And manager licensing was this vehicle where the state information office had real regulatory authority over association managers. And that was a little bit of a rocky start, I think, at first, but from my perspective, it worked pretty well pretty quickly after that. But now we have this HOA information office, and it's basically just informational in nature. It's advisory. It's not regulatory yet. But for 2025, going back to some of the previous bills to around 2013, we, meaning associations, have to deliver information to the state to keep track of what's going on, the number of delinquent owners who are late on their assessment payments, the number of delinquent owners who are late on assessments and other fees, including legal, so they can separate the assessment balance from the legal balance. Next slide, please. Number of payment plans entered into, number of legal judgments, and the number of foreclosures that an association brings. And that will be a continuing reporting obligation. From my perspective, it's not the end of the world, but I would say that many of the laws, the bills that have become law since 2022, have largely been invisible to our clients' boards. Most of these bills have been extraordinarily heavy backroom management company lifts on revising policies and getting processes and worrying about what information they have to compile and deliver to the state. So it has been stressful, I think, for management company owners and personnel in Colorado, just because there has been an annual change in how things are done. New policies every year, new form letters every year, new things to train up back office and support staff in terms of how they handle things. And this is another thing in that vein. I think one more. Next slide, please. Thank you. Okay. Do you mind if I talk real briefly, or do you want me to step aside about covenant violations in Colorado, Kristen?
We want to hear about it.
Okay. So I didn't know you guys were limited statutorily to a $100 cap on violation fines. In 2022, the Colorado legislature divided all covenant violations, all potential violations, into one of two categories: things that violate the public health and safety, scary, and things that don't. And for the things that violate public health and safety, the homeowner has 72 hours to cure after receipt of written notice of it. Now think about that for a moment. So when you look at it from the perspective of the legislature was trying to give homeowners a meaningful opportunity to cure before the machinery of the HOA enforcement mechanism started turning, I get it. But what about a high rise where people drop bottles off their 40th story balcony? Every year or two, we get people pinching lifeguards, at the pool. Public health and safety violation, in addition to being a crime. Is it realistic to allow them 72 hours to continue doing that after they got our letter saying stop doing that, before they have any potential fining potential or possible lawsuit? I don't think it's necessarily reasonable. The legislature's had a couple years to work on that bill, and they've consciously ignored changing that. And we face the same issue that you do, which is, how do you cure a violation? Because for every violation that is not a threat to public health and safety, it's essentially a 67-day cure. Okay, so you have to send out a 30-day notice of violation, certified in regular mail. After the expiration of the 30, if the homeowner has not responded within that 30, then you have 7 days. You have 7 days to inspect from the expiration of the 30. Not 8 days, not 10 days, 7 days. And then if it has not been cured, then another 30-day notice proceeds. If they give you photographic or visible evidence that the violation has been cured in the first 30 or the second 30, statute says the violation is deemed cured. And you stop fining and you stop doing all this stuff. And now, of course, if they lied at the end of that, you could, or anytime in between, you could go out and inspect and say, hey, we got your visual evidence of cure, and it's not indicating the conditions on the ground that we see. You might have a good conversation. After the first 30 days, if the homeowner has not cured it, you can fine up to $500 for the total violation. So if you fine $500 or you do 100, 200, 300, doesn't matter, but it's a statutory cap at 500. And then after the second 30-day period, you have the ability to sue the homeowner for injunctive relief, telling them to stop doing what they're doing or to start doing what they're not doing, subject to the association's obligation to subsidize 50% of the legal fees in the process. So from our perspective, plus we got a statute in 2022 that said associations can't regulate conduct on public rights of way. I don't know if that's something you have in California, but there are 2 cases in the United States, other jurisdictions, that said if the association's covenants say that you can't park on the public streets, even though the association doesn't own or control those public streets, it's an enforceable contract with the owner that they won't park on those streets. And so a number of communities in Colorado for years and years and years have been regulating private parking on public streets. And I've taken, several of those cases to multi-day trials and won. And now the statute says you can't regulate behavior on the public streets, which arguably not just applies to parking, it could apply to trash toters and pallets. It could be garbage. It could be weird things that people could do on the public rights of way that the association does not have any legal ability to influence. And here, at least in Colorado, we have streets, which are usually public rights of way, except for private association streets. And often there's a space of land that might be a strip of grass and a sidewalk, and it might even go onto the homeowner's front yard that is reserved for future expansion of the road, which is also a public right of way. So we sometimes get into these issues of trying to determine, does the association have the ability to regulate conduct on what looks like the owner's front lawn when legally it's a public right of way? So I know California takes the brunt of HOA jokes at the law seminars and the national HOA conferences. I think we're giving you a significant run for your money. And I think it's a little bit of the Wild West, good intentions, very little communication, and some of the bills that have been coming out, I think, they're just not fully baked. And it's unfortunate. As someone said earlier, maybe it was Alex, or maybe it was Tom, any bill we can adjust to, but when we don't know what the bill says, it's very hard to set meaningful policy without unnecessary risk. And that's the problem that we faced is, what does the statute say? I'm not really sure. So I don't know if the future is going to get any better. I don't believe that it is. We did have a positive thing this year in the legislative session for 2026, where a mandatory reserve study and funding bill for new communities coming online has been introduced, which I think is probably a positive thing. We had a mandatory reserve study and funding bill that passed the legislature in 2022, but was vetoed by the governor because the bill said that associations needed to be fully funded, didn't say by when, so the presumption was right now, and it did not, in its definition of fully funded, allow associations to special assess or borrow. And so the governor vetoed it based on this idea that it was going to quadruple or multiply many communities' assessments by 10 times or more. But we still don't yet have a mandatory reserve study and funding bill here. Maybe we'll have one for new communities, which from my personal perspective is helpful, because one of the most demoralizing things I do is go to a transition meeting from the developer to the homeowner control of the board. And the board says, yeah, the developer's been lowered the assessments. Now we have to raise the assessments by double. And if this mandatory reserve study and funding bill becomes law, hopefully the transition between developer control and civilian control of the board will not necessarily result in a significant assessment increase. So that's where we are. Take any questions if you have them. Or I can just keep talking for another 2 hours if you want.
Thank you
I'm gonna
so
say,
much.
David, I didn't think California could be top or bottom.
No,
but yeah,
we're making a run at it.
those are some pretty bad laws.
They are. Yeah, it's just, and it's cost, right? It's cost that is passed on to the assessment paying owner,
Correct.
especially with payment plans that go 18 months. If you're getting $25 a month for an elevator special assessment where you need the elevator, that's hard. And we had a insurance crisis here that you may have also suffered through in 2022 and 2023, where the market hardened dramatically, and we kind of got subjected to California insurance premium like circumstances. We had some clients anywhere from 15% increase to 1,200% association insurance increase, some with no claims history.
Yeah, we're still going through that crisis.
Yeah.
I'm sure you are.
Ended
We
for
got
you.
it.
That's amazing.
It was, and associations has to levy special assessment for to pay insurance, and the homeowners can pay it off over 18 months. It's hard to pay your insurance premiums, right? You can maybe defer the elevator repair, but the insurance company wants to be paid now. Even if you finance it, it's tough.
Well, that's a good point, because one of the laws that I referenced that's being proposed here about capping the increase of the assessments to the inflationary rate is that ignores the fact that insurance costs aren't being capped by that.
No.
We got the balcony bill repairs that they have to make. That's not being capped by it, and even just the cost of construction is not being capped by it.
No, all the things that associations buy are not limited to normal economic markers like inflation or the consumer price index. They're accelerating way faster than inflation in most cases. Asphalt roofing shingles and asphalt for asphalt parking lots, insurance, dramatic increase. And it's just, and I don't want to speak bad about a bill I don't understand or a legislator I don't know, but it just illustrates to me a fundamental misunderstanding of how associations have to operate, right? We don't have limited immunity. We don't have governmental immunity. If people don't like what's going on or feel that they're not getting the proper maintenance, they can sue the association. And we don't have the ability to tax, right? We have to beg for increased assessments in many cases, and then we have to pursue a larger percentage of people who don't pay.
And we can't print up our own money, and we can't borrow and never pay it back either.
Yeah, so that's it's really hard to tie your fiscal abilities of raising money to some number that does not match your reality. It's not going to work.
Well, let's see if anyone has questions. I do have some questions in Q&A. It looks like those are all California based. So I'd love to see if anyone is open to having their hand raised and speaking. You have a virtual hand. It's under reactions, and you can click raise hand. Or if you turn on your camera and you wave your hand between Jessica and I, because I just made her a co-host randomly, we might be able to find people waving their hands rapidly.
Before you do that, I neglected to point out that all the case law or the statutes that I mentioned, they just came into print today. Okay, so there's not anything for me to have given you before today, but you can go to caiclac.com and you can see the list of all the legislative session hot bills there. And it's to say the actual website is on one of the other earlier slides dealing with AB 130.
Oh, thank you very much, Tom. Okay, we're going to start with the live questions and then we're going to get into Q&A. We'll start with Catherine, and then if you could just clarify with your question if it's for California or Colorado. Go ahead and press unmute.
It's for California.
Thank you. Go ahead with your question, Catherine.
So we have our printed out fine in our CC&Rs. And the problem that we're having is, because we have mandatory fire alarm inspections and they have to go into people's buildings. And we have been just having a horrible outcome with the owner-tenant situation. The renter says they're responding. I as a board member, went to one of the units and the owner insisted that the tenant answered. And I said I was there. They did not. So because we have to call back the company again, we give them a 30-day notice, tell them when we're going to do this, tell them what day specifically their building will be inspected. And yet we have, we may have up to 3 or 4 people who are non-compliant. And so we flat out have a $250 fine because we have scheduled 2 events. We expect you to show up on one of the 2. And if you do not, then we have to call the company out. And then we have to go through that whole process of scheduling the inspectors to come back out. So I'm jumping the $50, $100 because this is mandated by the county. This is mandated by the state. These are inspections for fire purposes. Where do I stand?
Those
Good
are clearly
Safety.
health and safety violations, in my opinion.
Yes.
I don't think you have any problem finding more than $100, and you should find whatever the cost of having them come out again.
We do. Okay. I just wanted to make sure that that's what we were doing, and
My
I
humble
wanted to
opinion.
make sure we were compliant. Thank you.
Next question will be from Jennifer Trioche. Hopefully I said that correctly. Go ahead and unmute yourself.
Hello?
Hi, Jennifer. What's your question? Is it for California or Colorado?
It's for California.
Okay, shoot.
So, so we have a homeowner who has some kind of water, like a water issue, water flow issue. So when it rains, the water flows down a slope and it goes to the side of their patio and home. So I wouldn't say it floods their home, but there is some water penetration to the house, right? And they've been trying to get the HOA to fix this, but this is not in the common area. It's within their like fenced in area. So they're trying to actually sue, but they haven't gone ahead and done it yet because it says in the bylaws that they have to fix whatever that's within their property line, like within their fence border. Is there any way that they could actually go ahead and sue the HOA for something like this?
You could sue the HOA for anything. Whether or not there's liability there, it's like, to be honest, without looking at governing documents, and I don't think we could answer that. But yes, you could be sued for anything. I don't know if there's merit to the claim.
Thank you, Tom. Thank you, Jennifer. Next hand is from Don Christensen.
Hi, this is California. Two questions, but one's very quick, I think straightforward, is regarding I put in the Q&A, regarding the SB 410 requirements around the SB 326 EEEs. So if a report is already completed, I'm assuming that it does not need to be revised with the requirements of SB 410. So, I think a lot of what those requirements, the SB 326 needed to be completed by the end of 2024. And I'm not entirely sure, is it every 5 years, I think, for condos, or 3 years that it has the report completed? So do we have to revise it to be compliant with 410 as of right now, or is it for the next inspection report that gets completed?
Next inspection, it doesn't retroactively apply.
Okay, but regardless, those 2024 reports are part of the HOA documents and provided to new purchasers, right? So what's in them is in them, and they still see it. So
Yes.
Okay, thank you.
Thank you. All right, Rich, you're up next. Oh, Colorado?
Oh, I won't stop. I wish. No, California. First of all, thank you for putting this on. Being an HOA member, board member, president is difficult enough to try and keep up with all the latest rule changes, and you guys are really hitting out of the park with this one. Hey, just a quick question. We own all our properties fee simple, so there's not really a lot of this stuff is not germane to us. But I did have a question, and I think if you ask smart people, you come up with a good answer. The theory is that 2% of the people cause 98% of the problems. And my question is, we have somebody, or let's just say, how would you handle somebody at a board meeting that's repetitively and disruptive? I'm looking for a compliant cure for chronic interruptions during a board meeting. We have amended our CCR. We were thinking about memorializing with a fine schedule, but in light of the new legislation, what do you think would be best?
Yeah, I think first off, I'll just say, Rich, your music room looks fantastic. So just wanted to point that out.
I'm a musician. Thank you, man.
There you go. But as far as what you could do when you have a disruptive member at a meeting, one of the things that you'll want to do is adopt meeting rules. You want to have some, and to some extent, these will be rather general in that we're just trying to avoid disruptions. We want to be respectful, things of that nature. That's going to be the basis for any of the actions that the association would then want to take thereafter. So that would be step one. After that, I think depending on the level of disruption, requesting that individual leave sounds like it's within the right call.
Right. We've complied with the first part. We've tried with the second part, and they just flat out refuse to leave. The local police department says, we're busy. It'll be 3-4 hours before we can get out there. We have thought about just adjourning the meeting and then reconvening at some place, but it kind of violates the Davis-Sterling Act in that everybody else is not there. So this is a bit of a, we can't be the only board that's going through this. And wondering what you've seen that works.
You can do it all by Zoom and then mute them.
I like the way you think. Yep.
Mm-hmm.
Yeah, honestly,
one of
that's
the benefits of Zoom. Mm-hmm.
one of the thorniest and most difficult challenges there are for board meetings is where you have a disruptive person like that. It's very hard to regulate.
Right.
And I think Tom's suggestion, that's really the best one that I've come up with when there is that person.
Mm-hmm.
Do it by Zoom, hit the mute button.
Mm-hmm.
I know people don't love that because some people like their in-person meetings, but
Right.
you can also try holding a disciplinary hearing and relegating them to Zoom only and not allow them to come to the meeting.
So
but
would that
like
actually
you said,
is that legal?
I think so. Let them tell a court that it's not, and let you present the evidence of their disruptions. I think I'll have a sympathetic ear.
I knew if I asked smart people, I would come up with the correct answer. So will this recording, would this recording and slide deck be available offline?
Yes, it'll be distributed in a few short
Perfect.
weeks.
Okay. Well, thanks everybody. Appreciate your help.
Thanks,
Did
Rich.
you get your other question answered about SB 1007?
No, I was trying to not monopolize the meeting. So
Okay.
we have to provide evidence. I'm guessing it would be done via video, but we have a requirement that there's no video during our meeting. Didn't say the board can't video. Any words of wisdom on that?
Well, I don't think you have to produce, you don't have to manufacture evidence. I don't think you have to do anything you're not doing. You're not required to videotape meetings or so you don't have to do it. But if you, I think the idea is like, for example, a lot of associations, they'll take photos of a violation of the, like a nuisance or violation of the architectural thing. They'll take a photo. So you send the photos to them if you have
Okay.
them.
Okay. Because it almost I'm trying to look at what cubbyhole or what box to check. It almost rises to a harassive behavior. If we did fine and they just decided not to pay it, my thought would be small claims court, especially in light of the fact that the fine schedule is much reduced. And then we would have to get into the whole how many times did they violate, if they do these interruptions 5 times during a meeting. Is that 5 violations, or is this just for one meeting?
Well, I think one thing I would point out that the fines aren't meant to. It's not so much about you collecting the fines. The fines have got to be measured in a way to compel compliance. And so if you have to go to small claims court to collect the fines, I don't know how cost effective that is because you're obviously not compelling the compliance. So I think unfortunately, if you can't stop somebody from violating it, your next remedy is to file a lawsuit if it's important enough.
Somebody suggested that, like in business, there's a thing called progressive discipline, and if you get enough evidence, you could go to court to get a restraining order. They would not be allowed. The California Circuit Court would supersede the Davis-Sterling Act, and because of the 50-foot restriction, they wouldn't be allowed at the meeting. Just a thought.
You're mixing up a few things there. There's a civil harassment restraining order, which is going to be tough to get. The court sees some really bad stuff, and yelling at meetings isn't going to get you a civil harassment restraining order. However, you can still get a restraining order through civil court, but that's expensive. You go and get a TRO and you get a preliminary injunction. You can do that. It's expensive, but you can do it, and you get your attorney's fees if you prevail. But you should have a rule on point, like Alex was talking about. And you need the evidence. You need people to testify.
Well, hopefully other people have found this interesting, and I'll yield my time to other people now. Thank you so much.
Thanks, Rick. Rich, at least Scott also believes he was interested in that. He put in the Q&A that they have a disruptive owner over there. The problem is they won't admit they're being disruptive. That sounds familiar. I'm hoping the next one we have might be from somebody in Colorado. Terry, are you California or Colorado?
I'm California, actually, and I had a suggestion for Rich. We have some very passionate people who attend our meetings at times, and we've also had some physical threats because we have an outstanding lawsuit from a homeowner. So we now have a armed paid guard, and he can act as our sergeant of arms in our meetings, and he has actually escorted people out.
Thank you, Terry. I don't even want to know how much your insurance is, but that's awesome. Okay, next one is David Z. David Z.
California, and I just wanted you to repeat, Kristen, when will the recording be available?
I'd love to say tonight, but it's in a few weeks is the commitment. You'll see it before then. Most importantly,
will you be sending it out as an email or just a notice?
Yes, it'll go out through email.
Okay, great. I missed the first part of this. Thank you very much.
Oh, no worries. And most importantly, just so everyone knows, the way we build our programs is 100% based on your feedback. So when you get the feedback survey, please make sure you respond and give us your topics, because that is exactly how we build our topics. No other form is used to put together our topics. Okay, we do have a bunch of questions in Q&A. I was really hoping we could get someone that had something for Colorado. It looks like Mako might have something. Somebody is advocating for you. So let me ask you to unmute. Mako? No?
Okay,
Okay.
I'm from California. Can you hear me?
Yes.
Okay, I have a question to Tom. Tom, could you repeat again about reserve study? Something by 2032, we have to comply something?
Yeah,
Yeah.
yeah. Well, it's kind of hard to go over in like 2 minutes, but in essence, the bill itself is contemplating requiring a mandatory reserve at a minimum level, at the whatever the reserve study identifies as the minimal level for the period of time where you are in the course of the reserve study. The other thing about it too is it requires right now you have to do these reserve studies every 3 years, and it's requiring the boards to review specifically where they are as far as compliance with the recommendations on a yearly basis, which implicitly I assume they probably should be doing in any event, but required them to do it and try to bring it up to speed with that. So it's not hopefully the compliance deadline to be up to your minimum reserves portion of your reserves would be 2032, and that's the point in time where the reserve assessment would kick in and all compliance would kick in.
Okay, thank you.
It's not fully funded. We're not talking about everybody's got to be fully funded by 2032. That's not the goal.
We don't know what is the minimum level yet. Do we?
Well, you probably do. There's right now there's probably a recommendation in your reserve studies, and most of the ones I've seen has one. And even usually on the reserve summaries, there's a recommendation that what do you need to do to get to this minimum reserve? Like sometimes they'll recommend an assessment, regular assessment increase. Sometimes they recommend a special assessment to get to that. But there is one. It's just that it's not mandatory at this point in time, so nobody has to comply with it.
Thank you.
Thank you as well. Okay, another live question from Vicky.
Okay, hi. Thank you for taking my call. I have a question from Colorado. So the HOA information office, it's non-regulatory. You did give me the link. Thank you for that. But we're supposed to deliver information to the state on the things that you listed. What good does that do? What's the point?
Well, it doesn't do you a whole lot of good, but I think it allows the state to collect data about the scope of the problem that they're trying to address. We had this with the HOA information office prior to manager licensing, and I think they came back the first year and they had I don't know the number, 600 complaints, many of which were the same people complaining more than once. And we in the industry said, hey, with 12,000 HOAs, under 1,000 complaints in a year is pretty good. And the legislature looked at it and they, oh my gosh, we have a problem. So I think it's just to collect data for future legislation. Frankly.
Okay, thank you.
Yeah, you're welcome.
All right, next one is Luis. Or Luis, my apologies.
Hello. Yes, I asked a question on the Q&A about a violation lasting 4 days, and then the person cured the violation. But they were, as an example, they were blocking access to an emergency exit. We don't have the next board meeting until 3 months from now. So they cure the situation. Can we find them?
I think it depends on how you define cure. I think that's part of what the ambiguity on that, because I would argue that no, that was never cured. And if you're going to create that, in this case, that's a health and safety one. So if you're going to create a violation that if it repeats again is still going to create that type of problem, the violation has not been cured. I mean, I don't think you do that otherwise. And that's one of the things that I do think that the AB 130 fix is going to try to deal with. I mean, I do think there's a recognition of the certain events, that are temporal, that can't be really cured. I mean, they've happened, and you want to deter that activity. But even for example, like on the health and safety, what about somebody punching somebody on the common area, right? Or a dog biting somebody on the common area? It doesn't mean that they did it before it's going to necessarily happen. At the same time, you want to discourage that conduct from happening again. And so I don't think they've cured it simply because it's, at that moment in time, it's not happening.
Yeah, we struggle with this and have for the last couple of years, 4 years now, for what it's worth. And for, not legal advice, not licensed in California, but it is a problem, right? And sometimes you can identify a behavior that cannot be undone, right? And so sometimes we write language that defines those things that cannot be undone and say it's a cure is impossible. You can't go back in time and unpunch somebody. The other issue sometimes is trying to define an intermittent but ephemerally cured, like noise or trash toters or things that come and go so quickly. Sometimes we try to define that with language to say that if it is repetitive in nature with some parameters such that it indicates a pattern of repeated conduct, it's not cured. It's not constant, but it's not been cured. So those are the things that you'll have to figure out as you go forward with this. It's tough.
Thank you.
Okay, next question from Dawn.
Yeah, I think it kind of goes along with this, the cured and the time frame. And I liked what we heard from Colorado when, it's like you set those parameters of 72 hours, for it to be cured. And when we talk about things like parking violations, like they keep parking, extending into the main street. Yes, it's a safety, but regardless of the safety, if it continues to happen, would you recommend, we can say garbage cans, being left out, or just having crap all over their staircases and stuff. If you define something within 30 days, like if you have a numerical, like it continues to happen, like that's where the violation sits. I know then you have to allow them to have the disciplinary and show cause there, but then you're also defining if it doesn't happen in a 7-day, it starts over. Like it's I can't wrap my head around it because I keep getting to points of I can poke a hole in it easily. So I don't know how to define it with all the what ifs and buts on that. And Colorado sounds like they've gotten a little bit more guidance on the definition, but it's still.
No, actually, as Vicky, or I think it was Vicky said, 72 hours for health and safety violation. That's statutory. 67 days for everything else, and it does not define any part of the cure. And so the idea statutorily is, I think, if it's not static for 67 days, there's an argument that if they cure on the 66th day, you can't sue them.
But could we put something in there? I get it if it's not static, which static means constant, but can you define a variant of static to be like, if your show 7 days in a row, you don't do it. Yeah, I don't know. Like you put something like crazy on there to where it's like they have to prove evidence, meaning they have to take a picture that's time-stamped. I don't know.
I think certain of them you will be able to do that on, and some other ones, as I mentioned, are more, like I said, it's temporal in nature. It's hard to do that. If it's like I said, if it's the mere fact that and I think that probably everybody here has experienced this. There's sometimes there are people that cause a wide range of nuisance. Like, one day their dog is biting somebody else, the next day they're on the thing and they've kind of cursed at somebody or they've hit somebody, or they've done. There are people that do, and they got a bunch of different separate violations, So you say they're a problem, and if you don't curb their conduct, it escalates to the point where there could be something really bad happening. And at the same time, each time, if you define each time as being the only violation and it hasn't been cured, I would argue that some of that conduct would be uncured, conduct, or I would try to, but I think you'd have to, the devil's in the details, as David was saying.
Okay, we have 3 more questions in the Q&A, and then we have 1 hand. So we're just going to try to do some rapid fire on these last 3. Thank you, everybody, for sticking with us. I know we're past time, and Jeremy's definitely ready to send us off. So real quick, can an HOA restrict access to amenities such as pool for homeowner who is paying their HOA fees?
Oh, there's more to the question.
Yeah. I don't. Yeah, I think
check with your attorney.
Disciplinary hearing. You'd have to have a disciplinary hearing on it, and I do think it might depend on your governing documents, as to whether you could do it or not.
There's nothing in California statute that would prohibit you from using that as a disciplinary measure.
Yes, that's true. By itself.
It's very rare for us to do it, though. Normally, we only do it if you're also not paying your HOA fees. Guy has another question here. What can be done with an owner who piles items along his driveway over and over again, then donates them to Goodwill 2 or 3 times a year? This sounds personal.
Well, that's one of those ones that you can probably define that violation. Every time you leave it there for a month, that's another failure to cure, or 10 days. I don't know, whatever you wanted to pick. It's another separate violation. There's a possibility to cure. But, one of the things you have to keep in mind is that sometimes we're trying to, rationally resolve an irrational act or conduct. And so, that seems a little bit bordering on the irrational to me, but.
And if it maybe is a vector for rodents, or you could turn it into a health and safety violation.
Yep, I think so.
The thought.
Okay, last written question, then we're going to go to the last verbal question. On things like parking in a visitor's lot, if the violation is worded or explained as depriving a visitor the privilege of using a parking space for more than X minutes, it cannot be cured after the event. Huh? Why did that went way over my head?
I think the point here being we're again trying to define when something's cured, when something is a violation.
Thank you.
That's just going to fall down to what those documents say.
Thank you, Alex. And last question from Centeno.
Hi, good evening, everyone. I'm from California, and I live on a small unit. I would say it's 100 and plus units. I'm a current HOA member, and we are having difficult time trying to have homeowners come to the HOA meetings. And I was just trying to see what will be, you guys being the experts, give me an idea what can I do to catch their attention, because we have projects that we have going and we cannot communicate because and then when they find out, oh, I didn't know. And we do have monthly letters letting them know what is happening, but we still, it's like when they come and they come verbally strong as we did not communicate.
I think close a special assessment and then you'll get people there.
Right. Or fine them $100 for not coming to a meeting.
You're funny. Okay, so real scenario, what you actually need to do is declare a town hall meeting. And so you can have that be a portion of your regular meeting and just have it be an educational session. Have pizza, do something simple. I don't know if you have Costco near you, but Costco has $10 pizzas. So it doesn't have to be a real big deal. But a lot of communication and you'll get people there. Also, I know I think there's still a board member here from Atherton Place who has a lot of success getting neighbors there. And it has a lot to do with door knocking, getting to know each other, and creating community with committees. And then I think, what I will do is I'll turn the chat on for just a moment. And if you want to put your email address in there, and then Jessica Roberts, I'm sure she can get connected with you and then help you with some additional ideas.
Absolutely.
if I can figure out how to do that. If not, then we will find a way to connect with you. Actually, in the feedback survey, mark that you want the speaker to connect with you, and then Jessica can get you some additional resources. All right, and with all of that, we are coming in for a landing. Jeremy, you're up.
All right. Thank you so much, Kristen. Thank you so much for our speakers. What an amazing evening. Great insight, great information. I learned a lot. I'm sure everybody else here did. So join me, everyone, just thanking them for giving their valuable time tonight to educate us and spend time with us. So thank you so much for that. On behalf of Keystone, thank you for attending this evening, board members. It's a pleasure to spend the evening with you. I hope you got something out of it as well. Also want to say thank you so much for Kristen for putting on an amazing event, as she always does. Once again, you knock it out of the park. Proud of you. So thanks for doing that. And as a last reminder, you'll get a survey here via email. Make sure you take a few minutes to fill it out. Drop in comments, questions, as well as recommendations on topics for our next Night Out with Neighbors event. So once again, thank you so much. Enjoy your evening. Enjoy the rest of your February, and have a great night. Thanks for being here.
Thanks, everyone.
Thank you all. Good night.
Thank you.